respective position statement?
No. The letter that I received, I believe it was the end of January, basically outlined, going back pursuant to their retention schedule, various internal affairs investigations, and gave kind of a factual background. And these were internal affairs investigations that had been conducted that dealt with integrity issues and also issues, I believe, of inappropriate behavior in the workplace. And it just laid out what had occurred. And actually, I had already asked for that information from Lewis after his first interview, because, and all he was able to give me was just a computer printout that there was this investigation and what the finding was. He didn't go provide, it didn't include the factual underlying basis of what the issues were. So to me, I had already asked for that information, and here the city gave me a more detailed version of what I had asked of Lewis. So to me, it was just, it provided additional information, and it gave me the opportunity to look at whether or not the outcome of the investigations and how they impacted Commander Minor were disparate.
Why is it important to look at past practices and history when determining whether the city official acted appropriately?
Well, you want to look at whether or not is this person, and all government entities do it, is this person being treated differently than he or she has been treated in the past by this appointing authority or this department head who makes the decision? Because you don't want one person doing similar conduct and that one gets a suspension and the other one gets dismissed.
Can you determine what a historical practice is by just comparing to one other investigation?
Well, if there's just one investigation, I mean, it's a historical event, but obviously when you have multiple, it definitely shows a practice.
If you have multiple investigations to review, that provides you better evidence of the city's historical practice than just comparing to one other investigation. Would you agree with that?
Well, I think you can. I think you can with internal affairs investigations, especially because the allegations are pretty narrow. You know, like I said, an integrity violation is an integrity violation. And if it's sustained, how was that employee treated?
Okay. I'd like to ask you some questions about one of the policies that you reviewed, Administrative Regulation 333.
Yes.
You're familiar with that?
Yes.
You've also reviewed the general orders that apply to the two respective cases.
Yes. I don't have them memorized, but I've reviewed them.
Have you worked with AR 333 in other cases?
Yes.
Do you have an understanding of, in general, what would constitute a violation of AR 333 Part 1 versus Part 2?
Yes.
Can you describe for us your understanding of both the policy and practice with how the city applies AR 333 Part 1 and Part 2?
Part 1 are your, where the employee has violated federal law, Title VII, or, you know, and that includes discrimination based on gender, race, hostile work environment, and also retaliation. And you have, and how you determine whether there's a violation of AAR or Part 1 is whether or not it fits within the legal parameters of whatever it is you're looking at. Part 2 is just the general, you know, what you did was unprofessional, it's not appropriate in the workplace, it doesn't rise to the level of a violation of federal law or state discrimination laws, but we're not going to allow it to continue. And as the language that I always used to use is that if this conduct is allowed to continue, it could result in a violation of Part 1, but we're not there yet.
Okay. When we are discussing the differences between Part 1 and Part 2, there's a lower bar for conduct for for what constitutes a part two versus a part one. Is there a lower standard for discipline, for what discipline the city can impose for a part one violation or part two?
You know, I would say probably generally yes, but I don't know, it depends on how the city treats. I mean, I know the city of Scottsdale puts a very high value on what is called city values. And that is treating people professionally and appropriately. And I've seen some employees get fairly severe discipline just because they've acted, like, to put it bluntly, unprofessionally, inappropriately in the workplace, even though it wasn't a violation of part one.
In the city of Scottsdale, you could be fired for a part two violation.
Yes, I have seen that as well.
You have seen that personally.
Yes, I did an investigation recently, that was actually two, where that was the case.
And that investigation involved a high-ranking city official who had sustained an AR 333 part two violation and he was terminated. Is that right?
Yes, one was terminated and one resigned.
So, from an employee's perspective, being found to have committed a part two violation instead of a part one violation, it's not an employee catching a lucky break, is it?
It doesn't save them from being terminated, put it that way.
You're aware that some employees in the city have appeal rights where if they are disciplined, they can come here to this board and ask the board to revisit it?
Yes.
For an employee, let me start over. Because 333 Part 1 is a higher standard than federal law for the conduct, Part 2 is a lower standard for the conduct. If there's an appeal of any employee discipline, would it be easier for an employee to appeal a Part 1 violation than it would be a Part 2 violation, just because there's that higher standard that the city would have to prove?
Well, I mean, I don't know. If there's a part, I mean, I guess the part one would be easier to challenge because it's a higher standard insofar as the federal law requires more specific conduct, and also in some cases